As a continuation, what if after seizing of property, where shall the officer bring the seized property? So this is now the section 12, wherein the delivery of property and inventory thereof to court, return and proceedings thereon. Paragraph 8. This is not the answer. The officer must forthwith deliver the property seized to the judge who issued the warrant, together with a thorough inventory thereof duly verified under oath. So, after seizing the property, after searching, seized the property as described in the search warrant, then the such seized the property or object taken must be brought already to the judge together with an inventory verified under oath. It should be under oath by the officer. 10 days after the issuance of the search warrant, the issuing judge shall ascertain if the return has been made, and if none, shall summon the person to whom the warrant was issued and require him to explain why no return was made. If the return has been made, the judge shall ascertain whether section 11 of this rule is the receipt of the property seized, whether section 11 of this rule has been complained with and shall require the property seized be delivered to him. The judge shall see to it that the subsection A hereof has been complied with. So what if there is if the summon has not been served, if the search warrant has not been served, so what shall the issuing judge do? If there is no execution of search warrant after 10 days of its issuance, the judge shall summon the person to whom the warrant was issued and require him to explain why no return was made. Return means the property seized must be given to the judge as described in the search warrant. If the return has been made, the judge shall ascertain whether section 11 has been complained with and shall require the property seized be delivered to him. So that is if search warrant has been executed, then therefore he will ask for the return. The return is the object together with the receipt of the search warrant, well, if it is executed or not. The return of the search warrant, the return here refers to the returning of the document that is already the search warrant. It must be returned to the judge whether or not it has been executed or not. The return on the search warrant shall be filed and kept by the custodian of the logbook on search warrants, who shall enter therein the date of the return, the result, and other actions of the judge. A violation of this section shall constitute a contempt of court. So again, it is very important that after 10 days of the issuance of the search warrant, there must be a return. Return of what? The return of the search warrant, whether or not it is executed or not. If there is no return, the officer shall make an explanation why there is no return or why there is no execution of search warrant. Otherwise, a violation of the section 12, the rule 126, shall be a contempt of court. Let's move. Section 14. Motion to quash a search warrant or to suppress evidence. What to file? What's that? Motion to quash or suppress evidence. As we all know, motion to quash, it's quashing of information on several grounds. One is that the court has no jurisdiction. over the case filed, or the complaint or information constitute already or violating the double jeopardy, because facts and circumstances are stated therein are already the accused subject in the complaint or information has already been acquitted or convicted by the court, by the competent court, of the same cause of action filed against it. But what's the definition motion to quash? Here in section 14, motion to quash a search warrant or to suppress evidence. A motion to quash a search warrant and or to suppress evidence obtained thereby may be filed in and acted upon only by the court where the action has been instituted. Again, where to file this motion to quash a search warrant or to suppress evidence, it must be filed and acted only upon, must be acted upon only by the court where the action has been instituted. So where you if you file it in the Regional Trial Court of Zamboanga City, then therefore in a particular branch number, so only in that court that you will file the motion to quash the search warrant. If no criminal action has been instituted, the motion may be filed and resolved by the court that issued the warrant, the search warrant. So again, if no criminal action has been instituted yet, the motion may be filed to the issuing judge. However, if such court failed to resolve the motion and a criminal case is subsequently filed in another court, the motion shall be resolved by the latter court. So, it means to say, if the motion to quash was filed with the issuing judge in which there is no complaint yet filed, but subsequently, or such issuing judge failed to resolve the motion and a criminal action is subsequently filed in another court, so it should be in that court, in another court. So example, let's make this logically. If there is no criminal action has been filed, so therefore file your motion to quash to the issuing judge. If that issuing judge failed to resolve or failed to act on that motion to quash, then subsequently a criminal case is subsequently filed in another court, then therefore the motion to quash must be filed in that another court. That's the logic behind. Again, if there is no criminal action has been instituted yet, but you file, as the defense counsel, file a motion to quash the search warrant, file it to the issuing judge, the one who issued the search warrant. If that judge failed to resolve the motion to quash and a criminal action is subsequently filed in another court, then file the motion to quash to that court, or the motion shall be resolved by that court, by that another court. Do not anymore file the motion, because it will be resolved by the latter court, in which that court in which receives the criminal action filed. Now, remedy when the search warrant is quashed. What if the search warrant is quashed, granted, the motion to quash the search warrant was granted. Now, there are two situations. There is a case filed. As an incident to the main case, it is merely an interlocutory order. The remedy is Rule 65, certiorari, if there is grave abuse of discretion. Again, what will be your remedy when the search warrant is quashed? So, first, there are two situations. First, if there is a case already filed. As an incident to the main case, it is merely an interlocutory order. So therefore, the remedy, if there is already a case or if there is already a criminal case filed in court, then the search warrant was quashed. Therefore, file Rule 65, certiorari, if there is grave abuse of discretion amounting to excess or lack of jurisdiction. Next, what if there is no case filed yet? No case yet. There is an anticipation of the criminal case to be filed, but there is no case yet. Only an anticipation that a case is to be filed. Then your motion to quash was granted. The motion to quash the search warrant was granted. So what will be the remedy of the aggrieved party? What will be the remedy if the search warrant was quashed and there is no case and there is no criminal case yet filed? The order granting the motion to quash the search warrant is a final order already. The remedy is appeal. Again, if there is no case yet filed, it is only an anticipation of the criminal case to be filed, and there is granting of motion to quash the search warrant, the aggrieved party must make an appeal, because the granting of motion to quash a search warrant, even though there is no case yet filed, is already a final order. It's already a final order granting the motion to quash the search warrant. So the remedy of the aggrieved party is to make an appeal.